Your Honor, before we go ahead with our opening statement, I have several items I'd like to bring to your attention for dismissal. You have refused our preparatory challenge against the foreman of the jury, Mr. Herbie Pop, due to his statements made in public and documented as Exhibit A. Being that you have dismissed that preparatory challenge, we would also like to ask for dismissal of that juror based on prejudice. And you have received my paperwork and statements made by him in that case.
You have continually harassed this court with your frivolous proceedings.
I understand. Secondly, we would like to dismiss the entire case based on lack of evidence. There is no evidence. And I would like to cite the cases. 1970, the state of Nebraska versus Mrs. Penrose. She brought to the court the case of negligence for God because he allowed lightning to strike her house. But that case was dismissed also because God failed to turn up in court. The second case I would like to bring to your attention is the state of Nebraska, and State Senator Ernie Chambers filed a suit in 2008 seeking a permanent injunction against God for harmful activities as an effort to publicize issues of public access to the court system. That case also was dismissed due to reasons that God could not be contacted. So I am not sure how we can proceed in this case if there are stipulations that have been brought to the court that he does not even exist. How can we try somebody who does not exist? So I would plead for the court for lack of evidence on the plaintiff's side. This should be dismissed.
You're out of order. Proceed.
I understand. My second issue was we were asked for a nolo contendere motion, and we refused that because we will show, according to the court system, that the defendant, God, is totally innocent of all charges. So having made those motions for dismissal, I would like to enter into my opening statements to the jury. Good morning, everyone. I'm glad you're here, and I hope you understand that you are about to be involved in the biggest case in the history of mankind. The defense has had many years, decades, centuries to present their case. They brought their case. We've heard the defense. And now it's time to take a moment and go over what you are expected to do. We plan on a series of videos that will effectively put the burden of proof on the defense. And if I may reiterate what the court has given you for instructions. The standard set forth in this trial states, in a criminal case, in order to be found guilty, the finder of fact must find that the defendant committed the criminal acts beyond a reasonable doubt. Please do not forget that. We are in a court of law. We're in man's court now. We're not in the court of